topic. I'm surprised you didn't have more RSVPs, just because this is great stuff. And of course, anytime the government gets involved, it's incredibly boring and long-winded, and they do this only to trip you up. So, but I wanted to make sure that we touched on some things. Rachel had sent the presentation from last year, and I tried to incorporate a lot of that in there. And then this also pulls a lot from the presentation that we give to our own staff internally at Spectra. And the whole purpose of this is to make sure that we are being appropriate in the information that's coming in, knowing what it is basically and what the pitfalls are, and then making sure that we handle it appropriately and safeguard that security. So some of the things we're going to learn today, we're going to talk a little bit about the privacy laws themselves, but management of protected health information, minimum necessary standard, which is basically the gold standard of how much do you disclose. Designated record set, we'll touch that very, very lightly, but uses and disclosures, restrictions, what's the difference between security rule and a privacy rule, and authorizations and special exceptions, as well as some best practices as to how you can be more HIPAA aware in your workplace, regardless of your scenario. In our relationship at Spectra, most of the information that we deal with is protected health information. So everybody in our organization has to be mindful of it. And I'll be able to explain that a little bit more as to why that's so critical. But some of you and some of your employees may be having access to HIPAA related information without them even realizing it. Mm-hmm. And especially when you realize all of the pieces that are involved, it's like, how do we share anything at all? And that's a great question. So we're going to talk about some of those things. The first thing, HIPAA, not HIPPO, but HIPAA. If it has two P's in it, it's misspelled. But HIPAA is Health Insurance Portability and Accountability Act. It's a federal law, and it is designed to protect use and disclosure of PHI, or protected health information. There is a quiz at the end, so you're going to want to make sure that you have written down all the appropriate answers so that you can pass with flying colors. So the whole purpose of this is to protect the privacy of our confidential information, electronic and physical security of health and patient information. And especially in an HR scenario, you deal with some of those things, but sometimes when you're trying to be helpful to an employee, or just walking down the hall, you might come across something that really falls under protected health information. One of the purposes is to combat fraud and abuse of information. Now this is always cracks me up. Simplifying billing and other transactions. I don't ever see the simplification piece. And then improving health insurance portability, especially now with the exchanges out there where we don't have we don't have prior auth. In a lot of cases, a lot of that is due to the fact that this information moves, hopefully, across various platforms. My doctor, my personal physician, has been using her laptop to record notes for years. And she actually hauls a great big old laptop around with her from room to room, but it saves her, number one, gives her the protection of knowing that the information is secure, that she's not writing it down and then passing it off where somebody can walk by and see it. And then you have that transmittal of inappropriate information. Just a little timeline, just so you can get an idea as to how long we've been dealing with this. HIPAA actually started back in the late 90s, but in 2003, they actually started standardizing the transactions of they need to look like this. And then in 2004, just a few months later, the privacy rule, which is based around how our personal health information is used, or protected health information. And then 2 years later, the security rule, because that is about the time when everybody started pushing the big initiative for electronic medical records and electronic health records. And we're going to talk a little bit about cybersecurity and why it's so important, especially as everything moves more electronic. It's even more critical. Just think of this one thing. You go to the ER, someone has already hacked your medical record, and their blood type is now in your record. This happens all the time. Medical cyber attacks are very common. We've heard of situations with the University of Utah, different, when big health organizations lose millions and millions of records at a time, the potential is really, really severe. Needs to be not only, but as a consumer, we need to make sure that we are looking and reviewing our own information so that we are comfortable that that's our information and no one else's, okay? Mm-hmm. And then lastly, this was in 2013, there was a new rule that basically came out and said, okay, we've done the e-record, now we need to bump up the security, because as we know that it goes exponentially with what they can do. And we'll talk about business associates and the waterfall regulation that created. A business associate and a business associate hierarchy, basically it starts up at the top with the healthcare entity. So whether it's a hospital or whatever, I'd like to, the health insurance plan like IHC or Altius or Blue Cross, any of those, they're basically at the top of the business associate food chain. In the middle, you're going to have maybe a claims clearinghouse or a TPA or a broker like Spectra. We have to have business associate agreements with all of those covered entities. And then when we're looking at downstream, we also have to make sure that the protected health information we bring into our office is also guarded just as vigorously by anyone we do business with who would have access to that. Prime example of this would be our IT company, or you guys are responsible for being the gatekeeper for that information. But if we are putting information from employee censuses or claims data or whatever onto our servers, I need to know that the person watching the server is just as invested as we are. And so what the 2013 law did is it made each of us equally accountable. Their responsibility doesn't change at all just because they're farther down the chain. It's just as strong as if they were at the top. A business associate basically performs a function involving PHI, so like an IT subcontractor or even a consultant. If you had an external consultant who is evaluating all your claims data and making recommendations, they're just as responsible for that information as you are. And then it does require specific contract language that was added in 2013. So we had to redo all of our business associate agreements, and any agreement since 2013 has this new language in it that basically strengthens that. We also share this language with our clients that say, we understand the rules and we are protecting your information according to the law. So, it took a lot to do that, but that's what we have in there. So PHI stands for Protected Health Information. It refers to anything past, present, or future, or related to the provision of healthcare or that member. It's individually identifiable. I mean, if someone says, we did a survey and we know that there's so many households in Utah that do not have health insurance. Well, that's not protected health information. But if it comes out and says, we have done a survey and we know that Rachel Peterson doesn't have health insurance information, that's protected health information. So as soon as it becomes identifiable, then it falls under the PHI umbrella. And it means in any medium. Electronic was, in 2006, but any medium, written, oral, or electronic. When I was preparing this for our people at Spectra, I had actually found some videos online that had been created by a clinic. And it was a medical clinic or a hospital or outpatient surgery. And these two nurses were standing in front of the elevator and they're talking about, oh my gosh, have you seen the patient in room 104? They are just the biggest pain in the butt. She's just so ornery. Every time I go in there, blah, 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 blah. They get on the elevator and leave. The person behind is standing there and in tears. It's going, I can't believe they would talk about my mom like that. We just have to keep in mind of the information that crosses our awareness on a daily basis. And if it was us, would we want people saying that? Would we want that information out there? No, you would not. And some people are much more forthcoming when it comes to their personal situation, but a lot of people are very, very private. And this is there for a reason. And we'll talk about some of those mediums and what kind of information that's talking about. Now, this does exclude employment and research data, but those, if they're doing a survey or there's research data, they have different HIPAA rules that they have to comply with in order for it to be cleansed enough to be used for that information. It has to be approved in advance, and they can't deviate outside of those confines. So what isn't PHI? So we know that PHI is protected health information. SHI is summarized health information. So when you start pulling some of those identifiers out, all identifiers, what you're left with is a data set, which may or may not be useful at that point, but it pulls out the names, the addresses, social security numbers, dates of birth of all of those people, and hopefully gives you some aggregate information that you can use for your purposes. Now also, there are non-healthcare plans like FMLA, workers' comp, long-term and short-term disability. They do have parameters that you would still have to be mindful of, but they themselves are not isolated by HIPAA and saying, okay, this is the rule for this. The one thing I will spell out here is when it comes to workers' compensation, there are suggested guidelines and there's required guidelines. So if it's required that you have to release it to workers' comp, it doesn't necessarily fall under the HIPAA guideline. But if it's optional, you want to make sure you're following those guidelines based on the basis of the information, not necessarily who it's going to. This is a key term here, and this treatment, payment, and operations. This is basically accepted from a lot of HIPAA regulations, but it can be vague. Treatment, payment, operations. Of course, the people who are trying to pay the claim for your healthcare services, they have to know certain information in order to be able to pay that claim. They've got to know the date of service. They've got to be able to bump it up against your benefits. They have to look at, have I met my out-of-pocket? Have I done this? They also look at those conditions. Is this a covered benefit or not? So there's a lot of parameters. They have to do that in order to be able to make those claims payment. So when it allows covered entities to create, use, and share your PHI in order to be able to perform these administrative operations, we're good. We just have to make sure we stay within those operations and we don't deviate out there and, oh my gosh, you will not believe the ER case we had today. So-and-so came in, they had this thing in their eyeball. We just don't talk about stuff like that. It's a need to know, and we'll talk about that more. DRS, or a designated record set, this is basically what you're left with once you pull all those identifiers out, is the core information. A lot of times your TPA or your large claims report will have all of that with the personal information removed, because we want to make sure that you can't chase that back and determine who that individual is. Mm-hmm. In our market, the health insurance carriers do not release claims data for employers between or that are less than 100. Now, the employer would really love to have that information because it tells them how their plan is running, what to expect. However, when you get less than 100, it's too easy to start connecting the dots and figure out that that's, Stacy at the front desk or something like that, which is information we do not need to know. We do not need to have that information. Again, it excludes operational information like clinic schedules and things like that. Those don't fall into that, but anything which are not part of that medical treatment record can be de-identified under designated record set. Minimum necessary standard. This is really key. What do you need to know in order to do your job? Okay, there are people who go online and look and see whoever got arrested and try to search it down to see which of their neighbors are in jail. Is that really information that they need to know? Not really. But if you're trying to do a criminal background on somebody, you're going to do a background check, you're going to go through proper channels, you're going to get that information as it pertains to your need to know. If it's just idle curiosity, it's not appropriate. So, just no clearer than that. We need to exercise reasonable efforts. Now, this doesn't mean that you're going to be dinged for every single thing, but we need to do the best we can to make sure that we are not disclosing anything that doesn't have application to the job I'm trying to do. And for example, when you hire a new employee here, you're going to have them maybe do a physical, maybe do a drug test, do your background test, all of those kind of things. But the key thing is that employee signs a release saying, I allow you to do this, and it's okay to use the information that you get. That's a big difference. And basically, that's the fine line between what is acceptable and what is not, is that do I get the employees or the member or beneficiaries permission to do this? Okay, that's a big deal. Use and disclosure. So use is the sharing, like your employment application, utilization, examination, any PHI that are covered within the healthcare component. Sharing is what happens to it after we get it. What do we do with it? Do we post it on our social media website? I would suggest that's not a good idea, but it's the release, the transfer, provision, access to, or divulging in any manner that's not your minimum necessary requirements that deals with PHI. So, if you run across something that you shouldn't know, we and your company expects you to be an adult and not use it. Try to forget that you know it the best you can. Just, we know that that'll happen occasionally, but don't use that information, because then you are now precipitating a HIPAA violation, and your company has to record those and maintain that information for 6 years. And we want to make sure that somebody doesn't come 2 years from now and say, well, this violation happened, and then they look at your HIPAA log and there's no mention of it. So you want to make sure that you let your employees know that something like this happens, you need to let us know so that we can deal with it. Not that anybody's going to get in serious trouble, but if there's a hole or something in our process that needs to be adjusted, we need to know about it so we can fix it and plug it and move on. OCR, I would have never guessed this in a million years. I mean, it makes sense when you think about it, but all of HIPAA is under the auspices of the Office of Civil Rights. So, you think about HHS for the Health and Human Services, you have Department of Labor, you have, Employee Benefit Securities Administration and ERISA and everybody else. Well, now this is just another entity that's into the fray about how we do our business. It's important to realize, though, that there are some pretty significant fines involved here for violations, and blatant violations or repetitive violations, a minimum fine of $100 per infraction with a maximum of $25,000 for a multiple violation or an identical violation. So if somebody doesn't protect information and it keeps happening over and over and over again, those, even though it may have been 5 records that were impacted, they might bump it up to the $25,000 just because you're not learning your lesson here. So we need to fix that so that you do and you plug that hole. Wrongful disclosure penalties range from $50,000 to $250,000 per incident and can include jail time. I don't know about you, but I'm not going to jail for anybody. So let's make sure that we are just not being loose about how we manage this information. Personal representatives. When I talk about this a little bit, it'll make a little bit more sense, and you, those of you in IT are not going to have a whole lot of impact with this, but those of you in HR and in other scenarios might. If someone is designated my personal representative, I can basically determine how broad or how narrow I want that to be. If I just am a little confused and I just want them to help with my claims, I can give a personal representative for that. If I am not capable of managing my own medical care, maybe I have dementia or Alzheimer's, be quiet, Mike, but any of those situations, I can have a personal representative that has a lot of latitude regarding my medical care. So we think about maybe an aging parent or something like that. This is where a personal representative comes in most frequently. And someone who has medical power of attorney basically is that person's medical representative. However, if you have somebody who just has a language barrier or something like that and would like your assistance in getting a claims issue resolved, you can assist them as long as they know that that's what you're going to be doing. And if you're talking to someone in my office or even at the healthcare provider, they need to know that that person has given you permission to discuss their protected health information. They may require you to put that person on the phone and ask for identifying information, or they may ask you to actually fill out a form and sign that. I actually created a couple of forms, and these are for us as well, but sometimes we run into that scenario that we may be coming out to help one of your employees with claims. We want to make sure, and they think, well, it's my husband's claims. Well, I can't talk to you about your husband's claims because he's over 18, hopefully, and we can't discuss claims for a person that's over the age of 18 without their express permission. So I created, this is a two-sided form, and I'll let you pass those around. But on one side, it's a personal representative designation form. But the cool thing that's about this is you get to determine the scope and you get to determine the time frame. If I'm only going back 12 months for claims, or I only want you to deal with claims assistance or eligibility issues, I can say it's just to deal with claims and eligibility. I'm not trying to get prior authorization for a medical condition or anything like that. But when anytime there's protected health information, red flags should be going off like, is this something I should get them to agree with so I have a paper trail? Just to cover your butt. And even though it's like, oh, this just creates more work for everybody, I think that one of the things you'll see going forward is when our people come out and they're trying to help somebody with claims, they're going to ask them for their medical ID card and then picture ID. We want to make sure that their insurance card hasn't been stolen from somebody else, which is one of the most frequent methods of fraud. It's usually family member, either with or without the family member's permission, where the insurance cards can be stolen and used. And the person on the other end, the ER doesn't have any idea unless they've asked for a picture ID or something like that. So you'll find that people are becoming much more stringent about this. And if they don't have that information, we'll help you with it as soon as we get it. But I want to make sure. And we actually created some language for our people that says, if I'm face to face, it's like, in order to assure that your privacy is protected, I need to verify your identity. May I see your insurance card and photo ID? And if it's over the phone, same thing. I want to make sure your identity is protected. And can you give me the number from your insurance card, your date of birth, last 4 digits of your social? You just want to make sure you're matching that up. Mm-hmm. The bigger your company becomes, the more of an issue this can be. Now, federal law is, HIPAA falls under federal law, but state law can preempt it. So if Utah has a law that is stricter than federal law, state law trumps. So Utah law supersedes HIPAA in determining who is a personal representative. So in a situation where someone goes to the ER and the physician or the facility suspects fraud or abuse or anything like that, neglect, then the provider can step in and not necessarily have to get consent to treat if they have sufficient information that something funny is going on. If you've ever been or taken your kid to an ER and they come to you and say, well, yeah, you say they fell off their bike. I actually had this happen to me once. But I've seen a baseball bat do the same thing. And I was absolutely a basket case, but they needed to know whether or not they needed to step in on behalf of my child. Okay. Mm-hmm. When and it just changes and gets a little different. When we're talking about minors, parent, guardian, or other person acting in loco parentis usually has the authority to make healthcare decisions. You've gone out of town, you've left a letter with a relative or something that says so-and-so can make a healthcare decision for my child while I'm out of town. But again, you give dates on it. You limit that. Or right to obtain access to PHI about a minor child. So if you're calling the health insurance company about one of your children, you can access that information. Unless, when Utah law does not require consent of a parent or a personal representative. So if you have a child that is seeking contraceptive materials or treatment or diagnosis of a sexually transmitted disease or HIV treatment, they do not need your permission. The child can give permission to treat. Good, bad, indifferent, regardless of your personal feelings. That's the Utah law. And then the provider's judgment can also kick in if they think that the child might be a victim of abuse. They don't need the parent's permission to treat. This also goes to adults. So, for example, think about an aging parent. For example, I know when my mom redid her will a few years ago, they asked me to step out of the room so that they could quiz my mom about, do you feel safe? Do you feel like you're in a safe environment? Are you being pressured in any way to outline the parameters of your will in any specific way? They are very cautious about that kind of permission. Again, an adult's personal representative or conservator not involved, again, if they suspect abuse, but when Utah law does not require consent, like in elder abuse, or the patient consents to help. So basically, if I go into an ER and I need care, but I'm unconscious, the doctor will make a decision as to what I need. They will not treat me because I don't have somebody available. Okay, that will not happen.
So that's when they can do it without a consent.
So PHI is information about past, present, or future, and it can be written, oral, electronic. Now, this is my you can't hardly move without getting busted slide, because there are 18 HIPAA identifiers that could be linked to the identity of an individual. So I'm going to kick my little list up here. So think about some of the stuff. Oh yeah, we all agree on names, zip codes, dates, telephone numbers, beneficiary information, account numbers, certificate or license numbers. Even your driver's license number can be considered PHI. Vehicle information, including your license plate VIN. Biometric identifiers, including voice or fingerprints, a photo. All of these things can be considered identifiers. And then they cover it with number 18, which is, other duties as assigned, or anything else that they find that they think could be linked. Stuff that hasn't even come out yet, if they can do that. I recently got a new credit card that has the chip in it. It freaks me out that I have to put it in that machine and leave it there. People are stealing my stuff. But, that's how paranoid we've become, because we've all received an unsolicited debit card or credit card in the mail with a cute little letter that says, your stuff has been hacked. It's been compromised in some way, so now we're sending you a new debit card. I just hate that, because you don't have any idea where the hole is. So when does HIPAA apply to protected health information? Use it, disclose it, store it, see it on a desktop, talk about it in the hall, anytime, but just keep in mind that we're talking about protected health information. If the person does not want that disclosed, we have a right to protect that. So if you're in the hallway and someone says, oh my gosh, I just found out I'm having a baby, we're so excited. Well, they're sharing it with everybody. That's different. But if you found out they're having a baby and start telling everybody else and they didn't share it with anybody, that is a violation of protected health information. Okay. Now, so we know what we can't do. So what can we do? When is it not PHI, and what is minimum necessary standard referred to? So remember, we talked about TPO, which is treatment, payment, operations. You got to have the information in order to pay that bill and claim correctly. There's also a government request, so provisions by law, like we talked about, reporting abuse or things like that, or maybe a tumor registry, judicial and administrative procedures, so they can be court ordered. We all saw outbreak. We all know that, what happens, hang out with a monkey from Asia, but research has to follow the HHS guidelines. But public health activities like to prevent and control disease, if there was an outbreak of something in the city, they could access maybe identifiers or triggers or who has not been immunized, that kind of information, in order to, as a public service. And then, imminent threat to the person or public. For example, if, let's just say, this is an extreme example, but there is someone who's assaulting women, they find out he's HIV positive, and if you've been with this individual, you may want to contact us because he didn't disclose that to anybody. I remember something on the news about that about 10 years ago. And then you can also disclose it to the individual when handling a request for information. You go to the radiologist and you say, okay, I'm here to pick up my CD of my CAT scan. They make you sign that you've received it, but it's okay to pick that up. I can also send somebody to the pharmacy to pick up something in my behalf. But there's parameters around that. So we just need to make sure what applies to us and just be aware. So when is it not okay? You can't release information if it's not for treatment, payment, or operations. Casual conversation, again, I can't stress that enough. Also, there's a couple of protected areas. Psychotherapy notes is one of them. So even if the provider can get information, to pay the bill that so-and-so went to see a psychiatrist, the therapist can't release notes. He can release treatment, payment, operations, but nothing else. Okay. Also, HIV falls into this category too. This is also specially protected information. Research requests without approval, we talked about that. Let's talk about marketing and fundraising. When I was at Altius, we would have doctors that were opening a new clinic. They wanted to do a mailer to all of our members within a certain zip code, just saying that this is now a new provider available in this area. Welcome, come see us. Sounds innocuous. We were not allowed to do that because that requires us sorting our information and disclosing name, address, zip code of members in order to be able to send this out. So, after all of this happened, I was at Altius for 18 years before I came to Spectra 5 years ago. And, you used to be able to do that. It was not a problem. You used to have a social security card on the front of your ID card as well. Not anymore. So we need to make sure that if we want information, what is the purpose of it? And does it violate anyone's protected health information? We talked about the summarized health information, FMLA, sick leave, or workers' comp. However, even though they may not be subject to HIPAA, there's information involved there that is protected. So it may not be covered by the HIPAA law, but it's still protected. Health plan participation, enrollment, or disenrollment information. We could make Des and Rachel's jobs really difficult. We said, okay, we want you to enroll these people, but you're not allowed to gather name, address, date of birth, social security number, any of that other information. It makes it really difficult for you not to do your job. But if it's involved with the enrollment of an eligibility and health plan participation of an employer-sponsored plan, you can collect that information. You just still have to guard it. And then here's a key piece. If you get a signed authorization, one of these cool forms from an employee, what that does, so for example, when you did that drug test with their authorization, when you did all this other information, you have their signature, it changes it from protected health information to now it's part of their employer record because they gave you authorization to do that. That's why it's so important that you get this when you can. I agree, it's going to be a real pain in the rear implementing that type of policy, but when you start thinking about what's protected and what if it was my stuff, how would I want it safeguarded? And you let people know, look, with all the identity fraud out there, we are just protecting you, then it's a little easier to swallow. Now, I put this in here just because as an employer, we have different roles. Sometimes you are the plan administrator hat. So you're wearing this hat when somebody comes to you and wants to have your assistance with a claim. And if it's their own personal claim and they want your assistance, great. But we really, in these situations, we really encourage you to have your employees call us. That way we're taking a middleman out of the equation, and then we're on the hook for it, you're not. So you don't have to worry about, gee, did I get him to sign a form? Did I get their verbal permission? Did I make a note of everything? Let us help them with those kind of things. But there are going to be some things that are plan administrator, like enrollment and those kinds of things. That's when you're wearing your plan administrator hat. Your plan sponsor hat. This is when you send your plan out to bid. You start sending out maybe aggregated data for large claims and things like that so that a new healthcare provider can bid on your business, or when you're terminating a plan. What's your plan sponsor hat? And then you have your employer hat. So this is when you're dealing with stuff that pursuant to another federal or state employment related law, like FMLA, American Disabilities Act, workers' comp. These are other laws that fall under the employer hat that require you to be able to administer that. And it doesn't necessarily fall under the auspices of HIPAA because you have other laws that take place, but the information itself should be protected. And then this last point, I just can't make this enough. Getting that authorization changes that into employer data. You still have to keep this stuff on file for a certain number of years. You still have to make sure that you keeping the medical stuff away from your other employer records. You still have to follow the record keeping guidelines. It doesn't get you out of that, but it takes it out of the HIPAA bucket, if makes it a little easier. So minimum necessary standard based on your job role. And that's the key there, job role. If you're Rachel and she's responsible for the hiring for the entire company, basically nothing is off base to her. The receptionist, on the other hand, doesn't need to know that information, or someone else doesn't need to know it. Maybe their supervisor does not need to know it at that level. So based on their job role, and you need to look at that. And so whenever you create, receive, or use health information, you need to think about which hat am I really wearing? Is this plan sponsor hat? Is this my employer hat? Is this my administrative hat? Where does it fall, and how much more cautious do I need to be? Minimum necessary is the concept of increased confidentiality, and this is mostly just that whole awareness piece. And things are going to change frequently about how we deal with the information that is given to us. And that's always going to change. And as new techniques and hackers become better at what they do, then it's just going to get tighter and tighter. But the sender of the PHI needs to know and define the need to know stuff. Instead of releasing everything you got, if you just need to know their job history, that's all you're going to get. If you just need to know what their claims were last year, you're going to get that. But you need to make sure, okay, what's the minimum I need in order to do my job? If you consider, I don't want any of this information in my head, so what's the smallest amount that I can have and still effectively do my job? Less is always better. And the fines and penalties include sanctions or disclosures. And security breaches will be enforced by the Office of Civil Rights. Nobody wants to be referenced as, oh, remember the Target breach? No, Target's still not over that. We don't want to be listed in that. University of Utah, they really wish that whole thing would go away, but they didn't. And people were hurt as a result of it. So you need to be familiar with your policies and develop your own policies that relate to handling that information, and then make sure that you abide by them. So minimum necessary. So who is the request permitted? Is it a disclosure that's needed for treatment, payment, operations? Did the patient or the representative give you that authorization in writing? And are there any restrictions to the release of information? Are we talking about sexually transmitted disease information, contraceptive information for a minor child, maybe information for this, it's my husband. It's my husband. You've seen my husband a million times. I just need to help figure out this claim. He wouldn't know what to do with this information if you gave it to him. Well, that's great, but maybe you don't know that they got separated last week and they're in the middle of a divorce. You never have that information. If he signs off and gives you that, yeah, please figure out my claim for me, great. If not, you do not want to be caught in a situation where you released information because you didn't ask a question, okay? Because you don't know what happened last week. But that's why minimum necessary standard should apply to all requests for releases of information. And if we just do our due diligence and making sure that we're protecting the information that we have, and also making sure that we ask enough questions when someone asks us to intervene on their behalf, that we know what the parameters are. This basically just shows that when you have protected health information and you pull out those 18 identifiers, okay, well, what's left? Well, not much, but then it becomes unprotected health information. And if you're going to get by or use less than those 18 parameters, if there's even one left, the law says you need to have it verified by a statistician that it is scrubbed data, that it's a designated record set, and it's not going to violate HIPAA. Now, privacy versus security. The privacy rule came in 2004, and then the security rule came in 2006. So what's private? This talked about what is private. It talks about how and when it may be disclosed, when do you need to have an authorization, privacy policies. Like for a fully insured plan, the health carrier is responsible for the privacy policy. But if you move to a self-insured plan, then you're on the hook for those privacy policies and communicating that out to all of your employees, that you're protecting their information. It has to describe their rights, how the health plan can use and disclose their PHI, and summarizing your legal duties as well. So good argument for staying fully insured if you don't want to have to deal with that, just because you have to make sure that everybody gets that. That's why whenever we go and access care, we have to fill these out in triplicate because nobody wants to be on the hook for this, whether it's your doctor's office or the urgent care facility or the hospital. Everybody's got their own form and they all want sign off on that. Security is how do we keep it private? This only applies to ePHI or electronic PHI. The security rule does not apply to anything that's written or oral, even though we should still be cautious. But this particular security rule is dealing just with the electronic version of that information. So if it's a spreadsheet you send over to somebody without it being secured, or if it's a bunch of files that you left up on your screen and somebody was able to get information off of it. But this sets national standards for electronic PHI, and it requires covered entities and their business associates, keep that waterfall in mind, is that we all have to analyze our own risk and then put a plan in place to plug those holes. Protecting that information from accidental or intentional disclosure. Most people that are credible don't intentionally set out in the morning to disclose PHI, but it happens. And the accidental disclosures are just as important as those where somebody stole your stuff. So we just need to keep that in mind. CEs or covered entities, business associates, should periodically revisit their risk assessment to make sure that they have appropriate updates. You know, did they get new software? You know, their monitoring software on the front end. How did that change, and how does that change their HIPAA policy on the back end? But it's an ongoing initiative. It's not something you just do once and, you know, one and done. It's something that has to be ongoing. Security tips. Now this, I've got this down as HIPAA notes here. You can pass this around. This basically is something that, can I have one? Oh yeah, just this is basically security tips about HIPAA in the office. Now, even if your employees are not dealing with protected health information, you still have information that you don't want out there to the general public. That's why you have a receptionist. So hopefully you have that gatekeeper here to make sure that everything is monitored and that only people in the building are in the building and with knowledge and that type of thing. I did a site visit down in Gunnison, and it was a pretty good sized company down there, and they tried to tell me the reason we needed to sign in and put our email address and our phone number and all of this other information on there was because if there was a fire, they want to know how many people she needs to haul out on her back because they're wandering around the building. And I thought, okay, nice try, but it's HIPAA. It's, you know, you have industry secrets and things that are just proprietary to STG. Otherwise, you wouldn't be STG. So if somebody is walking through your building who is a workman dealing with your flood, how much of the information that your employees are dealing with on a daily basis do you want available? So it really makes sense to have security tips and things like that. And you already have some of these in place, like don't share your password, don't share your login, things like that. Lock your computer when you leave your work area. In our entity, I know I'm justifying you, Alan. In our entity, our cell phones have an encryption code. You know, they have a password. Our laptops have passwords. If I lose my computer because I have access to remote desktop on there, it's a security breach for Spectra. So all of these things are really critically important. Don't leave confidential information on your computer screen. Make sure you lock it up in a drawer when you leave for the day, or even if you're leaving your desk. Making sure that you're using locked shredder bins as a way to dispose of personal health information or protected health information. Using a secure email. With us, we have ShareFile, and if I'm doing an attachment, I have to send it through ShareFile. Rachel's received many of them, but that way she has to log in and open it, which means prying eyes are not going to be opening it unless they have access to that. Using cover sheets on faxes. Surprisingly, faxes are still a pretty secure way to do it, but you can't control who's sending at the fax machine on the other end. Unless you have a system where the faxes go into a repository and then someone trusted in your company is going in and pulling up the electronic version of those faxes and then sending them out to the appropriate individual. That's what we have at Spectra. We don't ever get a fax that just curls off the machine and falls on the floor for anybody to pick up. It just doesn't happen anymore. So as difficult as some of these things are, there's also a lot of tools that can be very helpful for us to protect our information. You have a privacy officer in your company. It is Rachel. And anytime you recognize a breach, you need to let Rachel know. And sometimes you may have to self-report, meaning I sent an email out and it wasn't secured because I sent it 3 times secured, and the client kept saying, I'm sorry, I can't get your email. I need you to send it to me just as a PDF. When we were doing the reporting this year, I would just die at the clients who would send me information unsolicited with, it's like, oh my gosh, you know, this is a breach. But that people are just not aware of what is required and what's important. Physical security of data, access, transmission, storage, retention of PHI, it must all be secured. So there's certain file rooms that need to be locked. You need to make sure that that line of authority for those keys are critical. Just because we know that, Carol always keeps the key to her desk under her potted plant. Well, Carol needs to be talked to, that's not a secure way. I mean, I have a key to the drawer in my desk. I carry the key on my key ring. Somebody ransacking my office is not going to find it. Anybody who needs to get into my desk will have to go through the receptionist and someone else in the company to get the key to unlock my desk in case I'm hit by a bus. So it's really important that you do that. We have a 3-minute timeout on our computer screens. If we walk away from our desk and are not touching our keyboard, after 3 minutes, it automatically goes to the lock screen. It is highly annoying. I'm just going to tell you. Mm-hmm. I hate it. I understand why it's there, but it's really annoying. So you find that you're talking to somebody and you're always reaching over, touching your mouse because you don't want it to shut down. One of the key things I think I learned the first HIPAA training I went to is if you hit that little Windows icon and L, it locks your screen instantly. The little Windows flag and L, go ahead and try it. Yep. It locks it. So if you have to run to the potty, Control or Windows L and you're gone. And then when you come back in, you don't have to risk anybody from coming in behind you. Whenever, okay, was it Kristen we did that too? It was Kristen. When she first started her company, she didn't know that it happened. And so she didn't lock her computer. And a guy in our company went to her desk and sent out an email to everybody in the company saying, pizza day tomorrow on me.
Oh, boy.
Yeah. Here, that would break somebody up in business. That'd be a house payment. So, but I mean, it was a silly thing, but it made the point. If you don't want, and so the thing is, once it happened to her, anytime she left her desk, if anybody saw her screen up, they would go there and mess with her. And she got to the point, okay, I get it. I'll do it. Stop. I can't afford more pizza. So it's really important that you put that on there. So the list that I have there, it lists those things that are confidential. On the back, it has all of these points I've talked about here. But just make sure that if you have inappropriate use or disclosure of PHI, make sure you report that to your manager and just make sure that we go through the proper channel. So if Rachel has to log it, she can, so that we can look and say, okay, and it should be part of your executive committee. Okay, over the past 6 months, these are the infractions that we had. This is what we can do to make that better. I actually have little cards that I print off. It's like one of those e-cards from Pinterest, and it shows a guy throwing papers in the air and says, I am blatant about my HIPAA violations. So when I run into a HIPAA violation, somebody leaves stuff on the copier, I find stuff left around, I find social security numbers left on a desk at all. I put one of these cards on their keyboard, and I'll tell you what, they do not want to receive those. When I was at Altius, the compliance officer, the HIPAA officer, would actually go through departments after hours and see what he could find. Not in an effort to make your life a living hell, but we need to find out where we need to be more vigilant. So the key for this is we want to build trust with our clients and with our employees that we're protecting their information. When you start thinking about it, we all have a lot of information about each other. And depending on your job, you have more than others. It's just important that they know that it's protected and that the things that need to be private are kept private. We're not going to prevent things from needing to happen, like your claims being paid or things like that. We just want to make sure we're cautious. Think about, what if it was you? What if this was your information? What deep, dark secret in your past do you not want on social media? Well, when we do not guard HIPAA, we're basically saying, just put this on Facebook. And we want to make sure that we're taking care of that. Any questions?
So I have a question.
You bet.
So you talked about kind of having a PHI signed authorization for employees. And,
Yes.
And I want to ask that question because
The one is like the one you filled out?
Yeah.
The different one? Your
Yeah,
confidentiality agreement?
Yes.
Okay.
So we don't currently have employees sign anything like that.
Mhm.
And so the question that I have is, in reviewing your slide presentation, some of the things that came to mind outside of our normal day-to-day business that we do capture, at least in this building too, for our office staff, we have our parking lot. So we have record of license plates,
Exactly.
things like that, that we do for a reason, because, we'll tow a truck or car if they're not,
Exactly.
supposed to be here, as well as photos. We have a lot of company events, we take photos, we have a photo booth that takes photos, we put them out there. We do have a photo release, but what would be your recommendation, maybe at the point of hire or through orientation, to approach this in a way that we capture that authorization? Not that we won't continue to be careful and gatekeepers,
Exactly.
but at least have something that says, we are going to be capturing this.
That's a really good question. We have pictures of all of our employees as well. And, frankly, if somebody wanted to pretend to be me, they could go to our website and they could snip my picture. Okay. I can't stop anyone from doing that. It's a public website. I agreed to have my picture on there. However, the originals of all of those employee photos are kept on a secure drive. So not anyone in the company can go online and get those. There's only a few of us that have access to that. So you want to do what you can. Okay. Try to think of some of the most extreme scenario. Someone's trying to avoid a stalker. Okay. If we're not guarding, you can't stop every scenario. You can just watch CSI or TV and you'll figure that out. You can't stop every scenario, but you can certainly do what you can to protect what you have. We don't put it out on the public drive. We don't make it available. You have reasons that you have vehicle information, but it's not available to every employee.
No.
It's secured. If you need that information, people who need to know it know where to go in order to perform their job. I need to get rid of this car that keeps parking in our parking lot. Let's verify and make sure it's not employee. If you find out it is an employee car, then what do? You say, okay, we didn't have correct information on you, or we wouldn't have towed your car. So we need to know that. That's why it's important that you let us know anytime this changes. Just like my address or anything like that. I need to let HR know because you have a job to do.
Yeah.
And it's in my best interest that you do that job. Did that answer that?
Mm-hmm. I think that's what's been great about having Benefit Compass is because they can go in and make those address changes and stuff, and it captures there, and then we can go in and update our information based on that.
Right.
But that's initiated by the employees.
Is this something you do now? You use
Yes.
now?
Yep. We have everybody in this room has signed one of these for last year.
The only thing I added to this was the very last one.
D.
Mm-hmm.
Okay.
And all that really did was, yes, I realized that I'm going to be required to successfully complete HIPAA training annually and re-sign this form every year. Okay. And that way you don't miss anybody. Nobody falls through the cracks. If you didn't catch them, it's like, okay, we're going to do this. And I mean, we have to do HIPAA training with all of our employees as well. And I really like this. I stole it.
Oh,
no, I really like that. So I think it's just real important that you think about those things, think them through. What would be the worst case scenario? What is a reasonable solution? Okay. Like keeping the pictures on a secure drive that not everybody has access to, those kind of things. At Spectre, we have an O drive. That's where we keep our agreements. That's where we keep our employee files. That's where we keep those kinds of things. And only certain people have access to that. Any other questions?
Yeah, you had listed on the PHI list, I think accounts was listed.
on the 18 identifiables.
Yeah.
Mm-hmm.
Are we talking, I'm guessing that's inclusive of bank account information,
Yes.
et cetera as well?
Mm-hmm.
So for direct deposit, we have through Spectra, they can do the direct deposit, upload the form.
Mm-hmm.
Now, in the event that sometimes that's tricky because, we're trying to get the direct deposit info right before payroll.
Exactly.
And we have to have HR assign them the task, and they have to go fill it out, upload it. In the event that we're trying to do it quicker than that, is it acceptable to take that information by phone call?
It's up to you.
Well,
I mean, if the employee is sending it to us, and
Right.
also by email, can they attach that form?
I wouldn't do it by
say no
email.
on the
Yeah.
Unless, you have an
Yeah.
internal secured document process.
Or if they password protect it and send the password separately. That's what I found myself having to do sometimes. But I think it will be a good practice that if we're talking to someone who reaches out to us, because a lot of us know our employees, but we may not recognize their voice or something. And I think whenever it comes to information like that, changing information or inquiring information, that we, a standard of practice might be to ask them to verify portions of the information that we have to say, let me verify
Yeah, just
you know,
pull out one
some
of your checks
security
and give this to me.
information
Make sure I'm not sending this to your
to
neighbor's
somebody else
bank
or
account. Yeah.
So we could take that over the phone, but definitely exclude receiving an email with direct deposit information.
yeah.
I
Okay.
think so. You want to make sure that you're
Yeah.
protecting that, and you're going to have employees who are going to go, hey, my bank account just changed, or my debit card got hacked, so I've
Yeah.
got a whole nother account now. And you're going to need to do that. Now, one thing like Employee Navigator, which is someone that hosts Benefit Compass, they are a business associate, so they have all of that security behind them as well. So once it's on Benefit Compass, it is protected. But
Well, and I wonder too,
Alternative ways to
if
get
you need it immediately too, I'm sure we could probably assign a new task in Benefit Compass to pull.
Well, we can. It would be nice to be able to have, I don't know if this is an enhancement we can do in Spectre, but it would be nice to be able to let somebody, when their bank account changes or when they have, to upload it at any time versus having to assign the task.
well, and I think some of the things you
Yeah,
have to make, we can only protect each other from ourselves for so long. You have to indicate there that if you do not update us when your address changes or your bank account changes and things like that, we're not going to accept liability if your paycheck doesn't get deposited and bounces back on the weekend because you didn't give us that information. So, there's got to be some accountability in both places for the information that they're giving you, for like keeping it updated, like your emails and things like that. Benefit Compass is worthless if that isn't updated. But on the other hand, you want to make sure whatever process is going to work best for you. And that's why you have to look at each of those pieces of information that you require as a standalone piece of information, because that's, in the grand scheme of things, doesn't mean anything compared to, their kids' date of birth and social security numbers, but it's just as vital for you to be able to do your job. So you'll have to figure out what works best for you.
We can talk to Andrea also, because it's like you said, if someone doesn't have a direct deposit, you want to be able to shoot an email or something to say, go into Benefit Compass now.
Yeah.
Update this.
And right now, it's a lot of communication
Right.
to make that happen. And if we just had a template,
Or
they always
something
know.
that-
And then we could run a report. Who
Yeah.
is anybody updated?
Yeah, I would
everything in the
prefer it
last
be
2
that
weeks,
way
right?
because-
That's what I would like.
I would prefer it to be that way because even authorizing it over the phone, there's no
There's no backup.
for you to say that you talked to me and I did it from a phone conversation.
Agreed.
Um,
And that happens. And the only quick way right now is email, which is not.
not secured.
Yeah, it's not secure.
I have to remind, we have to remind employees all the time, when they ask, like that question today about the W-4. And I said, here is a W-4 for 2016, you need to make some changes. I said, but please do not email this back. It has protected information and we want to make sure it's secured. So don't email this back to us. I did suggest a fax, which is our fax number,
Right.
which comes right to the benefit office in a secured, locked room.
Exactly.
That's occupied by people who are supposed to be in there, or password protect it and send it separately. But it's interesting because employees are, they just send information
And
out like that. And
most employees don't know how to send stuff through a regular email system, password protected. They just don't. And we just don't.
But I really like the idea of possibly having a fax, and I don't know if this is possible, but having a fax system set up to go right into a repository that doesn't, for employees that sometimes, because I know they're concerned. I know when I send a fax to one of our carriers, I wonder who's standing on the other end and who's picking up that fax.
They're getting an electronic.
Are they?
Well, because they are at such risk.
Yeah.
They're a covered
Because
entity.
that's what I
They're
wonder.
at the top
We
of that
talked about
food
that all
chain.
the time. I'm like, who is on the other end receiving that fax?
Yeah.
We can check on that one because
Yeah.
Andrew just went back for like 3 days for updates stuff to
For-
Benefit Compass. So
For
we can-
Employee Navigator?
Yeah, so we
Okay.
can check with her and see if.
Because there's a couple of
And that's
things
one I
that,
really don't think I would want fax because
Yeah, I
the
did.
employees, none of them have access to a fax
Yeah.
machine.
they don't.
I mean, but it is possible to even password
That would be
protect a flash drive.
I'll check on that.
So you can do it where you can set it up, and it's not hard. I just can't remember all the steps right now, but you can do it. So if somebody picked up this flash drive off of this table and I had PHI on there, they would not be able to open it. Or at least it would slow them down.
Well, and the one thing, the reason why this is getting so important is that medical information is now more lucrative to hackers than your credit card. Because they can download your medical information, set up a dummy.
Send it out to multiple people using your benefits.
Send it out to Blue Cross, Internet,
Yeah.
and that, and they can overnight, they could have $20-30 million in claims shut down and off they go.
That actually happened to someone I know.
So, yeah, so medical information is now becoming, so just get ready for next year's test. It'll probably be longer.
Okay, I do have a test, and this is up to Rachel as to how she wants to use this information. But what we do is there's 14 questions on the test. You can miss 3 and pass it at 80%. And then in Benefit Compass under certifications, I actually put in there 2016 HIPAA certification and mark it off as the date that they were certified. So a new employee, and then we just try to do our HIPAA certification every year around the same time for those individuals. But
So is that something that you would go into Benefit Compass and
No.
check off or do?
you're going to do it.
We do it.
Yeah.
Okay.
Yeah, you'd have to, because it's not going to apply to everybody.
Yeah.
You have a select group of individuals
Mhm.
that's, it's like insurance license. I have my insurance license in there. So you know, we can go through this. I know that we're kind of short on time.
Actually, we're here till 3:30.
Okay.
So we're okay. I
So
didn't
take
get
a
10
few-
though.
Okay, take a few minutes to go through and look at this. Yes.
Are we done?
Yes, we are.